Who testifies at a preliminary hearing in the state of Oklahoma? I'm Tulsa Attorney James Wirth, and that's the question that we received. So in the state of Oklahoma, by the Oklahoma Constitution, if felony charges are filed, you've got a right to a preliminary examination, which means a preliminary hearing where the state is required to prove by evidence, which is usually done by the calling of witnesses, that a crime was committed and that you committed that crime. So who is typically called for that? It depends on the type of offense it is. If we're talking about, some sort of felony domestic violence offense, generally you're going to have the victim testify. If we're talking about, possession of CDS, it's usually going to be law enforcement. Maybe if it's a crime that was charged on the basis of a traffic stop, you're usually going to see law enforcement. They're going to have their officers testify as to those things. But whatever they need to prove their case by that minimal level of probable cause is what it's going to be. So at a preliminary hearing, you see the state call a minimum number of what's the fewest number of witnesses that we need in order to establish that minimum burden. Whereas when you go to trial, you're going to see it's a lot more witnesses are called, a lot more detail are put in. It's going to be the bare minimum at the preliminary hearing. So one, that's because it's less work, less time for the state. Two, preliminary hearing is a benefit to the defendant. They get to cross-examine these witnesses, and they can use that essentially as a tool for discovery to find out what people are going to say so they're not surprised by it at trial. So strategically, the state doesn't want to give the defense much opportunity to examine their witnesses, so they're going to bring the bare minimum. Now, as far as what witnesses are called, what about the defense? Does the defense call any witnesses? Well, sometimes, but it is rare, and it's rare for a couple different reasons. So one, just like the state doesn't want to show their cards, the defense usually doesn't either. So if they have an opportunity to talk to their witnesses and know what they're going to say, it doesn't make sense to make them available to the state for cross-examination prior to a trial. That just allows the state to have a discovery opportunity. Two, if law enforcement reports are provided to the defense at least 5 business days ahead of the preliminary hearing, then the preliminary hearing cutoff is going to be applicable, which means that once the court finds that there is probable cause a crime was committed during the state's case in chief and probable cause that that the defendant committed the crime, then the prosecutor can ask that the preliminary hearing be cut off, and the court will do that, and that happens before you get to the defendant's case in chief, so the defendant may not have even an opportunity to call witnesses. So for that reason, it's unusual for the defense to call witnesses. However, I have done so in a couple different cases. One where I was concerned that a witness may not be available in the future, and I thought that and they were not cooperating readily with the defense. So I wanted to get them in because I thought they had good testimony, got them in, subpoenaed them, got them under oath, got that evidence that I needed so that is set in stone in case they're unavailable for trial. That can be a reason to do it. So strategically it can be done sometimes, but it's unlikely. But generally you're just talking about 1 or 2 witnesses for the prosecution is usually what you see at a preliminary hearing. So if you're dealing with felony charges in the state of Oklahoma, though, you're going to want more than just general information from video. You're going to want to talk to a lawyer privately and confidentially to get legal advice. To get that scheduled with an attorney at my office, you can go online to makelawEasy.com.